Hi listeners, Jason here. We are excited to finally announce registrations for the biggest psych health and safety community event ever. The inaugural The Psych Health and Safety Conference will be held at the Sofitel Wentworth, Sydney, June 19 to 20, 2024 and offer concurrent virtual attendance. It'll feature live podcast recordings with OG researchers including Christina Maslach and Michael Leiter of Burnout fame, Psych Health and Safety USA podcast host I. David Daniels, Australian super experts including the likes of David Burrows, a special 10-year anniversary integrated approaches to workplace mental health panel with authors Tony LaMontagne, Angela Martin and Kat Page, hand-picked case studies from organisations doing it well, and a very special interview with plaintiff Zagi Kozarov by Catherine Dunlop on that High Court case which we previously covered on the podcast. This event will sell out. Get in quick to secure tickets at early bird prices for the 2-day conference, pre-conference masterclasses, and the VIP dinner. The first 200 in-person registrations also get a copy of her latest book, The Burnout Challenge, signed by Christina Maslach herself. Find out more and register at www.psychhealthandsafetyconference.com. Now, on to this episode.
From Flourish DX, this is the Psych Health and Safety Podcast. With workplace mental health becoming a safety prerogative, this is the source of information on psychological injury prevention and health promotion.
Hi, and welcome to the Psych Health and Safety Podcast. My name is Jason Banshee, and I'm one of the hosts of the show. The aim of the podcast is to rapidly increase the knowledge and application of psychological health and safety in workplaces worldwide. To help with this, we have regular guests from around the world who are leading the way in this important area. But before I introduce our guest and topic for today, allow me to introduce my co-host, Joelle Mitchell. How did I, Joelle?
My mouth's burning a little bit. I had to go next door to get some lunch, and there was unexpected chili in my lunch, so a little bit mouth's a little bit singed.
Yeah. What about your nostrils?
My nostrils are okay. Yeah.
Yeah. Nice. Yeah. It's something I crossed my mind the other day. Like mouth pain is something that is like really only felt by the person suffering it, and it's really hard to convey kind of like the discomfort that you might be in. And it's.
I think that goes for any kind of pain.
I know, but just mouth pain.
That's why the hospital uses the 1 to 10 scale, right?
Yeah. But mouth pain was something specifically that I was thinking about. Like I got a cut tongue or
What
ulcer
happened
on my
to you
cheek.
that you were thinking about mouth pain?
It actually wasn't me. I think it was someone else who was trying to convey some pain, but I think
Right.
like a cut rather than a
Yeah.
inadvertent chili hit.
Mm.
Yeah. Anyway, interesting. There's probably a parallel to psychosocial hazard exposure there as well, which I'm sure our listeners are smart enough they can connect the dots. We don't need to perfectly lay out the analogy for everyone.
Maybe something about tolerance and something about levels of heat.
Yeah, we can stay on topic. Yeah, for sure.
Mm.
Yeah. All right. Well, look, our guest is patiently waiting, so she's probably let her in. Okay. So let's introduce her. She is a lawyer. And as such, she regularly supports clients in crisis management and incident response, safety investigations and prosecutions following serious safety incidents, and regularly acts in coronial inquests, personal injury matters, and administrative review proceedings. She supports clients to manage work health and safety legal risk and to develop proactive and practical health and safety compliance strategies in relation to psychosocial health and safety and workplace conduct. She is a partner in the work health and safety team at Herbert Smith Freehills. Warm welcome to the podcast, Nerida Jessup.
Thank you both for having me. And actually, I do think there's a bit of an analogy we can draw. Can I?
Yeah.
Bear with me?
Okay.
I think mouth pain, what you're talking about is subjective. Some people enjoy pleasure of their mouth burning up. Other people are buckling under the pressure. We're talking about hours of work. It really is a subjective issue, and there is no kind of one size fits all approach here, which I think is really one of the challenges. So wow, perfectly. The perfect
See, I
analogy.
told you our listeners and guests could draw the line. We didn't have to lay it out.
There's something in it. But
Yeah,
thank you
yeah.
both for having me. It's really great to be here. Good to see you both again.
Yeah, and Nerida, often our guests say long-time listener, first-time caller. I believe you're a short-time listener. but we won't hold that against you. You did help us with a webinar last year that we didn't broadly make available like we did the podcast. The webinar was on due diligence requirements for company directors, so that was really useful. But yeah, really looking forward to the discussion today on a different topic.
Yeah, me too.
All right. So to get us started, Nerida, what podcast do you like to listen to?
I have a number of favorite podcasts. Is this a recurring question? I'm really into a podcast called If Books Could Kill. That is one of my favorite podcasts.
They probably could.
Have you guys heard that?
Thrown right velocity, right
If
angle.
it had enough heft.
Yeah.
Yeah. So I'd put that right at the top of my list, actually. Love that one.
I haven't heard of that one.
No, I will look at it.
Have you not?
I
No.
like
It delves into, I guess, airport pop psychology and pop philosophy, like really best-selling books. And it's a critical analysis of those books by an ex-lawyer and a professional podcaster. It's an incredible podcast.
Yeah, that would be good. Yeah, I think we'd both enjoy that one. So.
Yeah, if there's one thing that we both hate, it's pop psychology. All right, and can you tell us about your professional career, please?
Yeah, so I'm a partner at Herbert Smith Freehills in Sydney. I lead the safety practice here. My practice sits inside the employment, industrial relations and safety practice at Herbert Smith Freehills. I have a fairly broad practice. I do a lot of incident response, crisis management work, but I also do a lot of advisory work. So that due diligence seminar that we run together, we do a lot of advising boards and management teams on setting up WHS governance systems. But broadly, my practice is safety, risk management, crisis management.
Yep. And so how did you get to where you are now?
That's an interesting question. I actually started out as an IR and employment lawyer many, many years ago. And I, over time, developed a real passion for safety. There are a couple of really big matters that I worked on. Commission of inquiry into the floods inquiry actually probably really changed my view about thinking about safety and systems and organisational failure. And very, very early on in my career and at university, I always thought I'd be a criminal lawyer. So this has combined that kind of employment, industrial relations, safety background, and that love of criminal law really well. And about a decade ago, I specialised. I decided to specialise in safety. So that's how I ended up here. This is probably a fairly roundabout journey to where I've been. I've worked for individuals. I've represented regulators. I work for public and private sector, and I work at a range of safety associated matters, personal injury, coronial inquiries and inquests. So it's kind of a broad practice area, but I got here through a fairly broad and diverse professional background, I'd say.
Yeah, nice. I think sometimes the twisty pathways are the more interesting ones.
Yeah.
Yeah. Funnily enough, I wanted to be a lawyer, and I did. I was living in Sydney at the time, and I did a placement with Edmund Barton Chambers actually. My career advisor at the time said aim high when deciding on work placements, and I think they were level 50 in the MLC tower at the time on Martin Place. I was like, I took it quite literally, and then I found it really boring. And so I'm glad I didn't do law, but I'm glad there's people like you who have a real passion for it, Nerida. So look, the reason we wanted you on to talk to, I guess, a legal matter is recently Australia's Senate passed a bill that would prevent an employer from contacting employees outside of work hours, which is being referred to as the Right to Disconnect Bill. So could you tell us a little bit about that bill and how it came about?
Yeah, so the Right to Disconnect reform was kind of a late insertion into a broader legislative suite of changes which have been introduced by the Labor government, the Closing the Loophole Bill. Essentially, the Right to Disconnect reform was brought in at the last minute as part of kind of last minute negotiations in Canberra to actually pass this broader suite of reforms, the Labor reform agenda. So it felt like it was kind of a bit of a last minute inclusion. I don't know how well planned for or thought through it was in the end, but it it got there in the end, and it was part of passing this closing the loopholes reform agenda from the Labor government. So we have ended up with it. It's come into place. It has just received royal assent, so it hasn't actually taken effect yet. We've got 6 months from royal assent until it takes effect, but the right to disconnect bill will come into effect this year, and there's a suite of changes which gives effect to that general, as you've said, that right to disconnect.
Yeah, it's interesting how you say it was kind of like it felt very last minute. I mean, Joelle and I aren't lawyers. I don't know if you knew that it was coming down the pipeline, Joelle, no, but I only really saw it when there was a big hullabaloo, you could call it, on on LinkedIn, going, what is this? And like, where did this come from? And some people praising it, some people, going, oh, this is the end of the world. So how, tell us a bit about how it came about, right? Because this didn't just turn up overnight. Like you said, it's part of a broader suite of legislation changes. So it'd be interesting to know if you have some of the, like, how did this come out? How did we get to this point?
How do we get to this point? In relation to the right to disconnect reforms, that actually wasn't part of the initial closing the loophole reform which has been proposed by the Labor government. You will have seen that was on the agenda for some time. And in order to pass those reforms, there was just some last-minute negotiators from lawmakers in Canberra to actually slip this into the bill. I think it was actually proposed by the Greens. In terms of whether there is precedent for this type of law, there is not in Australia. We haven't actually seen a right to disconnect formally legislated in the past, but there have been examples of this used overseas. So we've been aware of the concept and the idea of some jurisdictions having these right to disconnect laws in place. But I would say it did come as it felt a bit rushed. It hasn't formally been on the Labor reform agenda for the whole time of this Labor government. Whereas, and it's not even their big ticket reform. There's been a suite of pretty significant industrial relations changes that were actually passed through as part of that closing the loopholes bill.
Yeah, how does this this bill relate to some of those other Labor changes?
I think the through line here really is that it is an additional right, an additional employee right, that aligns, I guess, with the Labor agenda. What it does is essentially it means that an employee has an enshrined right to disconnect. So that is not check emails, not monitor emails, not respond to emails outside of hours if that requirement is unreasonable. There are a range of mechanisms which under the Fair Work Act have been inserted to really give effect to that, that general right. So there is an ability for an employee to apply to the Fair Work Commission for an order to either stop an employer from requiring them to, let's say, respond to emails after hours, or take action as a result of them exercising that right to disconnect. The right to disconnect has been added as a protected attribute, which essentially means that it is now unlawful, or it will shortly be unlawful, for an employer to take adverse action against an employee for reason of them exercising a right to disconnect. So that kind of is what it looks like as a legal mechanism. But there is no precedent in Australian law for this particular right. We haven't had, previous iterations of this as yet. There is a concept, and I think you and I have spoken about this in the past, of reasonable additional hours in the Fair Work Act, and there has been since the Fair Work Act was introduced, but this is quite a different right here.
Yeah, so I guess you've mentioned that there's kind of more of the international precedent or examples of other countries having similar laws in place. How does this particular bill compare with those international laws?
Yeah. It, For example, in France, I think they've had a right to disconnect or a similar right to disconnect in place for many, many years. The mechanics of it are quite different. And, anecdotally, some people will tell you it hasn't made a huge difference really in France or in some of those other jurisdictions. But it really needs to be looked at in context. There are powers available to the Fair Work Commission here. There are I think other than the general principle that there is some concern about employers requiring employees to work 24 hours a day or respond to emails at night, the approach to looking at these laws is to actually make sure you're across the detail of how this works and having in place a plan to respond to this ahead of time, ahead of these powers and this right taking effect.
And is the word reasonable in there somewhere as well? Like
It is.
reasonable contact out of hours?
The right is not absolute. The right is to disconnect if the requirement to check emails is unreasonable. What is reasonable is actually codified in the Fair Work Act, and it takes into account a range of issues, including the nature of the role, any additional payment that is given to an employee to actually be on standby to check emails, the salary of the employee, the reasons why the requirement to check emails or monitor emails or respond to emails outside of hours is imposed. So, yes, the reasonableness of any requirement to respond to emails outside of hours underpins this whole reform. The right to disconnect only arises if the requirement is unreasonable.
And if you're not working for a small business, I believe.
There is a little leeway for small businesses.
We're going to stop hiring people. Yeah. Interesting. So we're obviously in Australia going through, I think unprecedented is one of the words of like the decade so far, but unprecedented IR and workplace health and safety legislation reform is happening concurrently, right? So how do you feel this bill might intersect with some of the reforms that we've seen around psychosocial risk management?
Yeah, exactly. So this fundamentally is an employment and IR issue, and it touches on it squarely addresses psychosocial health and safety. The justification for this is that, in part, the reasonableness of hours and the requirement to work and respond to emails outside of hours is a psychological health and safety risk. And we know that, right? We know that unreasonable hours, high work demands can be a psychosocial health and safety risk. And I think this reform is some effort to address that, as are the changes that we've seen in the work health safety space. So the introduction of specific psychosocial health and safety regulations which require employers to turn their mind. I think there's a really direct through line between a reform like this, some of the litigation and challenges that we're seeing in the reasonable additional hours space. Again, and this is fundamentally an employment industrial relations issues, but under the Fair Work Act, one of the national employment standards is the 38-hour week plus reasonable additional hours. What is reasonable additional hours is, of course, not defined, but one of the factors, and probably the factor most discussed at the moment that will be taken into account when determining what reasonable additional hours are, is any risk to health and safety that is introduced by working those hours. And, traditionally we would have looked at hours of work. And when I'm saying traditionally, I'm talking, before 5 years ago, where these issues have become front and centre, we would have looked at hours of work from a health and safety perspective, really as a physical risk. That if somebody is operating machinery and they haven't had enough time to rest and recover from their prior shift, that actually presents a physical risk to them and to others in the workplace. More and more we are seeing that shifting to, well, there is a physical risk, particularly in some industries. But this impacts all industries. This is a risk in, for want of a better word, white collar industries. It's a risk in offices. And that is the psychosocial health and safety risk that can arise from working long hours. But as I said, doesn't always. So it is a risk. It's a risk which we have seen squarely named in the health and safety guidance in the codes of practices. But we are seeing legislators and policymakers dealing with, and courts as well, courts and the commission dealing with in that what we would have traditionally looked at as employment and IR issues. The fact is there's just not a clear delineation between the employment and IR aspect of this and the safety aspect of this.
Yeah. Yeah, it is interesting, right? Because we have had like working hours codes of practice for some time, but the main thing that they're trying to resolve, like you say, is fatigue impairment rather than
Yeah, that's
the
right.
psychological injury. But we know there is that relationship between working long hours and burnout and other psychological injuries. Um, Interested to hear what your thoughts are, because you said like part of this you consider how much people are paid. And it's funny because if I think about investment bankers and other really high paid roles, just because people are paid really well doesn't mean that they can't develop a psychological injury. So how do we kind of reconcile that we can't just danger pay, or can we? Is that what the legislation is saying? Can we danger pay our way out of injuring our employees?
Yeah, that's a big question. I don't know that danger pay is the right way of thinking about it.
It
And as you said, there's
depends which angle you're looking at it, though, right? If you're looking at it from an IR angle, that's different from looking at it from a work health and safety angle.
I think one of the pieces of advice the IR team are kind of giving in relation to preparing for these laws is very similar to the advice that you would give from a health and safety risk planning perspective. That is, look at your workers, look at your workforces, your workplaces, and look for where this might be an issue. And you're quite right. So there are whole industries and whole workplaces where long hours of work is a risk factor, where because of international demands, client demands, in the legal industry, court demands, there are a number of issues which feed into whether this might arise as an issue. I'm not sure that long hours per se is necessarily a very good indicator of whether somebody is doing well. I think some of the key issues here are making sure that you've got the right approach from management, that managers are able to monitor hours of work, monitor workflow, communicate with suppliers and clients in relation to work demands, are able to monitor for signs of mental ill health, and that we've got processes in place for where there is significant, if you are working through a period of significant work hours, that there is rest and recovery. That system won't be appropriate in all industries. Some people are attracted to those kind of high performance cultures, and they will actually flourish and do well if that risk is managed well. If you are able to identify the risk, this is a team, this is a cohort of workers who are likely to be exposed to this risk. How do we manage it so that we get the best out of our workers, they get the best out of their work? But I don't think there's necessarily, I think looking at some of this, there seems to be, is there a number? Is there a maximum hours of work that we can work? Or is there a time at which it would be unreasonable for a worker to be required to monitor their emails? And the answer is likely no. This really is looking at your own workforce, looking at your own workers and making sure you've identified where it might become a problem. I think for some type of workers, working long hours would be adverse, would be much likely to adversely affect health, or it might be at various times in a worker's life likely to adversely affect health. But I don't think you can say that for everyone. I think some people will really flourish under those kind of high work demands. But that said, that traditional thinking of, well, this is a difficult job. You work in this area, it's high performance, some people burn out. That's really not, there's not anything we can do about that. I think that thinking will not get you very far when you're dealing with a right to disconnect order application, or you've got a knock at the door from a safety regulator. You really need to have thought through and put processes in place ahead of time to deal with that risk.
Do you need more psych health and safety in your life? Then head over to the Flourish DX Academy for several free on-demand e-learning courses. If you're an internal professional, follow Flourish DX on Eventbrite to register for any of our free fortnightly interactive webinars. Our flagship professional practice program is also exclusively available for internal professionals. The 12-week course blends theory, applied practice, and interaction with other professionals through live lectures and a monthly community of practice session. Find out more about all these learning opportunities or inquire about a bespoke in-house training at the Flourish DX Academy. www.45003.org. Now back to this episode.
Yeah, and I would imagine there's some stuff around like realistic job preview kind of perspectives as well, right? Like,
that's right.
Do we hire people on a 38-hour-a-week contract when we know that actually everybody in this particular role routinely needs to work 50 hours a week? Like, let's just be clear up front and say, well, this is the standard requirement.
I think so. I think that some of this is about setting expectation, whether we do it in our employment contracts or in our policies and procedures. If you're working in an international role, there is an expectation that you will be checking emails overnight, or that I think that's quite right. That the expectations and what we as employers think is reasonable is communicated early on. I think that's a really good call out for this, but it does actually mean we've got to look at our workforce and say, where would this be reasonable, and where do we think we actually need to adjust some of our practices to make it clear that that's not what we expect from those workers. We don't expect them to be checking emails overnight.
Yeah. And I think we're going to get to it probably when we talk about some of the downsides potentially of this bill. But like from what I'm hearing from you, it's sounding like this is kind of a blunt instrument that doesn't really pick up on the intricacies of how harm occurs due to psychosocial hazard exposure.
Yeah, it will remain to be seen how it is used.
Yeah, don't let me put words into your mouth. Nerida didn't say it was a blunt instrument, everyone. But
and it's an IR instrument. It's not a instrument.
But I think if we think about the complexities of psychosocial hazard exposure and harm, we know it's often not just exposure to one hazard that causes harm. It's the intersection and culmination of a number of different hazards, right? So like you say, Nerida, you can have people who are attracted to working long hours or working in those competitive high demand roles.
Yeah.
But often they might have really great supports in place, like they might have a really supportive manager or a high level of decision-making latitude in their role, those sorts of things, maybe even autonomy to have, rest breaks when they need it, interspersed throughout the day rather than a normal kind of like 9 to 5 job. So, I guess we need to consider this bill and what it requires of employers in light of, I guess, a range of different things they should be doing to consult with workers and protect the health of their workers.
Yeah, I think that's right. I think the key from a health and safety perspective is to identify, just back to basics, identify risks and hazards that our workers might be exposed to. This is identified as a psychosocial hazard. Right? So we have to be alert to it, and then we have to put systems and processes in place to reduce the impact on workers. And then on top of that, we have to have responsive processes as well, that that the duty under WHS laws is not absolute, that where workers have adverse mental health events or suffer ill health, work is likely to be named as a factor, as is various other life experiences, plus, what's baked into us. There is a complexity to looking backwards sometimes. So I think what it requires is recognising the risk, putting the systems in place from a WHS perspective. This is a separate standalone right. Partially there's a kind of an industrial agenda behind it, partially there's a safety agenda. I think putting those processes in place, and I think in particular, Dolly, what you said in relation to setting expectations early will be a really big part of getting ready for these laws. If we are very clear about the demands of the role from the beginning, then that will go to the reasonableness of requiring that. Some of the factors that will be taken into account by the Commission when asked to look at what is reasonable, though, will actually be the personal circumstances of the individual. And very much like the psychosocial health and safety risk processes we've got in place, you'll have an organisational level one, but then you also need to consider the teams and the individuals and how these are managed. But I think that they're getting at the same thing. And I guess what I would say in relation to the putting in process the psychosocial health and safety processes will put you in good stead to then prepare for these laws. It will be a really key part of it, of being confident that we as employers have formed a view about what's reasonable, that we have communicated with workers about what is reasonable, that our managers are aware of what's reasonable, and that we have taken steps to mitigate any risks of checking emails after our, for example, there's little tweaks that you might make as a manager in relation to, this is sent from an international jurisdiction, you don't need to respond in my time frame. Some of those, there just might be a lens that we take to the psychosocial systems that we've already got in place. Like, have we put enough in place in this hours of work, considering the new right to disconnect reforms which have been introduced?
So I guess leading on from that, what should organisations already be doing to minimise their expectations for employees to connect outside of working hours? I guess in preparation for
the new laws.
Yeah.
Yeah. The first is, I think you need to develop a view across the business of what it is that will be reasonable in terms of requiring workers to monitor and respond to communications outside of hours. We should identify the basis of that reasonableness as well, if they're working international roles, if there is urgency to checking overnight, if there is, as they're kind of a highly paid, high performance subset. On top of that, there should be the psychosocial health and safety thinking attached to that. So where there is a requirement to work longer hours, or we think it's reasonable that they work longer hours, what are we doing to actually mitigate any risk to the individual worker from working in that role? Looking at, for example, the risk of burnout. What are we doing to mitigate those risks? A key part of responding to these laws will be making sure that decision makers as well are trained, are given training and are aware of these new reforms. There is potential for exposure to general protections claims if it is alleged that a decision maker has made a decision or taken adverse action against a worker, including because of their exercise of this right. So it can introduce some complexity in those decision making. So if we're talking about the downside of this type of reform, it does create complexity for employers in making decisions. So there will need to be some education to management in relation to these laws. as you said, we could be looking at job descriptions and employment contracts to make sure that we are clear about expectations of communications after hours. There should be a process as well in place. So reviewing our policies and procedures, including, how to resolve any issues with communications after hours internally, before it gets to the commission. So we should make sure that the policies and procedures internally are reviewed. There might be steps that we take which are, what we would refer to as controls, I guess, in the safety space. What controls can we put in place in relation to this? Should we be adding a sign off to an email saying you don't need to respond to this straight away? Would there be a process in place where managers are working long hours because for whatever reason it works for them, they're doing flexible work, where they actually delay the sending of some of those communications? Are there communications that we need to have with suppliers and clients to really push back sometimes on those demands for responsiveness overnight? So I think starting that process now, if and really leveraging some of that work that may have been done in the business in relation to psychosocial health and safety will put you in a better position when these laws do take effect.
And would you advise, I guess, some level of data collection or other type of information gathering for the PCBU, if you like, on like how often is this actually happening across the business?
Yeah, that's right. I think utilising your tech and monitoring some of these after hours communications will be helpful, and it's going to be an important data source as well, both at looking at where this is actually going to be an issue in our organisation, but also if there is if an issue is raised by a worker as to whether the level of communication outside of hours is unreasonable, there will be it will be useful for employers to be able to rely on objective sources of data in relation to levels of communication and levels of outside of hours contact for those workers. So absolutely, I think that's right.
So I did kind of flag before that there might be some downsides, and let's face it, like, when we bring in instruments like this, it's not going to necessarily suit everyone. It's not all going to be upside. And in fact, I did read that Peter Dutton had already pledged to repeal the laws if the coalition wins the next federal election. So there's obviously, he feels voters might not necessarily like it as well. Liberal Party may be appealing more to employers than employees traditionally. So yeah, what are the potential downsides to this?
Yeah, I think if you kind of zoom out, there was a lot of consultation, let's say, before the WHS prescriptive health and safety regulations were introduced. I think there was a lot of lead-in time to that reform, and
yeah, we're still waiting on Victoria. They've got lots of lead-in time.
When you compare that process to this reform, it feels rushed. It's difficult, I think, from talking to my IR colleagues about what will be the impact of this. There are stop bullying orders and stop sexual harassment orders available in the Fair Work Commission. A lot of them will say, well, they haven't been used to their full extent necessarily. It's not necessarily the first port of call for workers. But any new reform, particularly in the IR space, brings additional complexity and, here, additional legal risk. I think in particular, the complexity in relation to decision-making, which potentially could be the subject of dispute in the kind of general protections realm. So I think I think that's where a lot of the criticism of these laws has come from. And also, there has been an obligation, we say, well, there's always been an obligation to ensure, so far as is reasonably practicable, the health and safety, including psychological safety of our workers. over the last 5 or so years, there has been increasing recognition that that includes psychological health and safety. And a lot of good work has been done by our safety regulators in relation to what that means in practice, including in hours of work. So I think many would say, well, we've got an obligation really from a health and safety perspective to look at hours of work and to make sure that any outside contact is reasonable. There is various regulation that sits around hours of work already. And so, this is an additional layer of regulation and complexity there. So I think that's probably where some of that commentary is coming from and getting at really.
You could say the same thing about the positive duty under the Sex Discrimination Act, though, couldn't you?
You could. And in fact, that was, you'll recall when the Respect at Work report was first handed to the then Liberal government minister, the initial response to the Respect at Work report was to adopt some of the recommendations, but not all of them, including that the Liberal government funded Comcare, to develop an inspectorate dealing with respect at work, and said essentially this obligation already exists and it exists under WHS laws. That was kind of the initial reaction to that recommended reform. A couple of years later, we've actually seen that introduced by the Labor government. We've seen the positive, separate, parallel duty under the Sex Discrimination Act. Yes, it does actually, it introduces complexity because you now have two regulators dealing with a very, very similar duty with very similar powers. So you've got the Australian Human Rights Commission and your safety regulators both investigating compliance for what looks to me to be essentially the same duty. So I think that's a good call out, and I think that's part of the criticism here is it does seem like layer and layer of regulation dealing with the same thing, which necessarily will create complexity.
Yeah. What seems different here, though, is the ability to make a stop doing it order.
Exactly. No, that's right.
Which, yeah, if you're an individual making a complaint about an individual case to a WHS regulator, it's probably not going to do much for you. Whereas if you are successful in getting a stop doing it order, that's a different thing.
I think the individual rights and the potential for general protection litigation in respect of this is certainly, they're really concrete examples of individual, of issues that employers will have to grapple with. Whereas I think with the sex discrimination positive duty and the WHS duty covering off on sexual harassment, you would say, again, this is about forward-facing systems. If you have a system in place which addresses that general duty, then that essentially should cover off on both of your duties. And, as long as you've considered the best practice guidance published by the AITC and you're looking at the safe work guidance dealing with the same thing. But I guess the message is the same. There is a fair bit of complexity. The policy and legislative reform has been so rapid over the last 5 years. It's a lot to grapple with.
So, any final recommendations for employers in as they journey towards meeting the requirements of this new bill?
Yeah, I think the key message is to be prepared. Really look ahead. Where is this likely to impact our workforce? And form a view, what's reasonable, and then take steps to make sure that is communicated, that's fed into all of your systems, your employment processes, your contracts, your training, so that you are ready. You use this lead in time for the changes to take effect. I also think a lot of this work is good thinking for your WHS duty in any case. If you haven't looked into the issue of working hours and you are you are in an organisation where there is an expectation of working outside of hours, it is a worthy exercise to actually to do the work in this space as well.
Mm.
Well, Nerida, it's been a very interesting chat. You never disappoint. Now, you won't know this because you don't listen to many of our podcasts, but this is another staple question of our guests. So what are your hopes for the future of workplace mental health?
I think that there is a hopeful change in process. I think a lot of these, particularly in the safety space, a lot of these reforms have come about because WHS regulation has been, seen as pretty effective in the physical safety space, that it's contributed to better, safer outcomes for physical safety. But despite that, there seemed to have been this anecdotal increase, worrying increase in psychological ill health contributed to by the workplace. I think that the hope here is that that employers are able to actually put these systems in place, and that there is a better outcome for workers. I think some of the complexities here too can be overstated. A lot of these, there's a lot of common sense here. There's a lot of just looking at your own workplace and your own workforce and working out what are the risks in our business and then how do we address them. I think sometimes we get very, very tied up in the complexities of this. And so my hope is that, employers take a confident approach to addressing some of the hazards and risks in their business, and that they're actually able to drive better workplace cultures, more healthier workplaces, and that there is actually a shift in some of those worrying trends, which I think brought about all this law reform in the beginning. So that's a long way of saying I'm really hopeful that this does drive, positive change. And I think we've already seen it for many employers who really have had their eye on psychological health and safety. I think that it has been a bit of a hopeful story.
Yeah, I got to say, I was helping to facilitate our first community of practice session for our second cohort of our professional practice in psych health and safety program today. And I had a question from someone who seemed quite disconcerted with the state of things at the moment, and was asking, so how long until this just becomes the normal practice of businesses? And I said, well, I think for the companies who started their journey, maybe 3 to 5 years before it becomes more embedded into just the way they operate. Broadly in Australia, maybe a decade. It's going to take a while before it just becomes common practice across everything, as most big changes do. But I said, put it this way though, if you're a migrant worker working in the Middle East, you don't know if you're going to come home alive at the end of the day. So burning out is probably the least of your worries. So we're actually very fortunate to be tackling these quite progressive problems here in Australia.
Yeah.
And some other countries don't have the same drivers as what we have, even though it's a significant risk to people's health. So.
Yeah.
So perspective, I said deep breaths, patience, and perspective is how we get by. Yeah.
Agreed.
And Nerida, do you have any words of advice for listeners who want to work in the field of psychological health and safety?
Well, I think it's no longer just in the legal world. It's there's a lot of paths here, is what I'll say. I think increasingly I'm working with IR and employment lawyers. They're getting across psychological health and safety. We're all talking about workplace conduct. So I think it's a key part of certainly what I do in the safety space, but I think it's a key part of anybody working in HR, employment, and anything dealing with people at work. I think you'll find your way there.
Yeah, it's a pretty broad area, right? Like it intersects so many different disciplines. So yeah, and we find that from the guests on the podcast that they can come from varying backgrounds. They're not all from an org site background like Joelle and myself. That's for sure. Well, Nerida, like I said, you never disappoint. I always love our conversations. You're fantastic. You're articulate. So thank you so much for coming on the podcast.
Thanks for having me.
Yeah, I know the listeners are going to get a lot out of this one.
Thanks so much, guys. Lovely to be here. Thanks for having me on.
Great. Well, listeners, that brings us to the end of this episode. Remember, we do video these when we have the conversations with our guests. So you'll be able to find this video and past videos on the Flourish DX YouTube channel. We also take snippets of these conversations and put them on the Flourish DX LinkedIn page. So follow that for the nuggets, if you like. And while you're over on LinkedIn, if you want to continue the conversation, you can hit up Joelle, myself, or Nerida directly over there. But thanks a lot again. We'll catch you next episode.
You've been listening to the Psych Health and Safety Podcast. To stay up to date with the latest on psychological injury prevention, follow Flourish DX on LinkedIn and subscribe to the Psych Health and Safety Podcast at www.psychealthandsafety.com.